Yes, Mr. Dillon. We just finished stacking down.
We had, my lord. And may we go straight on, therefore, to Jones
Yes.
and Kerr. The effect of Jones and Kerr, if I can summarise it, was that the court can infer a common intention to share the beneficial interest, draw a factual conclusion, that is to say, as to what the parties' intentions were from circumstantial evidence, but could not impute that common intention. But where it was possible to infer an intention to share in principle, but not possible to infer what the shares intended were, because their common intention did not go that far, as a matter of fact, at that time, it is permissible for the court to impute a common intention the parties may never have had. That's the quantification stage. So that's that, in my submission, is the effect of Jones, or the clarification that Jones made of Stack. As your lordship has already observed in the head note at E, there was a finding that Mr. Gurnett had cashed in insurance policy, or that the parties had cashed in a joint insurance policy so that one of them could buy himself a new home. There was a finding that the parties' intentions changed, and there was detriment found, or detriment in the facts, not only by the cashing in of the policy, but far more besides, and we can see that from the argument which your lordship already referred to. I don't accept my learned friend's comments on the chronology behind that. But in any case, it wasn't in issue, wasn't put in issue by the respondent. Paragraph 14 of the joint
wouldn't have been.
Judgment, sorry, my lord.
It wouldn't have been. If anybody was going to put it in issue, it would have been Miss Jones, wouldn't it? Yes. No?
Yes, we saw in the argument that there was ample evidence from which the trial judge could, and that, as your lordship says, was in the submissions for the claimant, the appellant.
Yeah. Right.
So turning to the judgment itself, the lead judgment, the joint judgment, paragraph 14 it was the point I was making earlier, where the two judges say it was accepted that the parties' common intentions might change over time, producing the ambulatory constructive trust. An example given in paragraph 70 was where one party had financed or constructed an extension or major improvement. The principal question in this case is whether this is one. So my submission, there's a little bit of a danger there, because what I endeavoured to show your lordship earlier was that the type being referred to by Lord Hoffman was the ambulation of beneficial interests in an inchoate way at the quantification stage, which one doesn't actually need to look at until the end of the day, the trial, what's happened. But like a proprietary estoppel in that sense, what's the phrase that Lord Newburgh used? The owl of Minerva spreads its wings only with the gathering of the dusk, or something to that effect.
That from Lord Hoffman too.
We
got it from Hegel.
Yes, yes, that's the derivation. And what it means, of course, is that the judge looks at everything that's gone past and makes a decision as to where you've got to. One doesn't actually need to poke into the facts along the chronology and say, well, at this stage it's 75-25, at this stage it's 85-15. And what His Honour Judge Madge did that he didn't need to do, if I may say so, in Barnes and Phillips, was identify that if he had been deciding the case at one date, he would have decided 75-25, but as it is, further things had happened, so now it's 85-15, and that's where the confusion has been caused. So that's paragraph 14, and at paragraph 15, the simple statement of what Stack and Dowden decided, the default option is the beneficial joint tenancy. And what the lordships say there is the trust can be classified as a constructive trust, but it is not at odds with the party's legal ownership, and that is crucial. It's not at odds with the party's legal ownership. The only reason, in my submission, it is a trust at all is because Section 36 of the Law of Property Act says that every time you have joint proprietors, there is a trust. And the reason I say that Section 36 says that is so that the machinery of the Law of Property Act can bite.
Right, in 1925 it was a trust for sale.
Yes.
And the purpose of it was that the purchaser didn't need to investigate the devolution of the beneficial interest, and he needed to concern himself with the legal title. That's the effect of having a trust for sale. And it got replaced in 1997 by a trust of land. How does the conveyancing machinery work with a trust of land? Does it work in the same way?
Well, we also have, in the 1996 Act also says that a trust of land is a trust, even when it's jointly held on the beneficial interests mirror the legal interest.
Yes, but how does the conveyancing machinery now work? If you're a purchaser from joint owners, you're presumably not concerned with the beneficial interests.
Well, if you're buying from joint beneficial owners, then joint legal owners, then the beneficial interests are overreached.
Yes.
And that's why this restriction is in the form that it's in. Paragraph 16 is where in Jones the Supreme Court refers to that passage in Grant about there being no special doctrines of equity applicable in this field alone. Paragraph 17 makes clear that it's the starting point that's different, not the rest of the principles in play. I won't go through it all in minute detail, but the overarching point is that there are numerous places within this judgment that their lordships could have made the point that they're disagreeing with the requirement of detrimental reliance. And there's references indeed also to Lord Newburgh, Lord Newburgh's dissenting speech in Stack and Down, where he does refer to the need for detrimental reliance. And yet,
normally, I think he says.
He does say normally, and I think in a later case, which we'll probably won't bother coming to, but in a later case, I think that was described as not actually meaning to limit it to any specific category of case.
Yes.
Lord Collins, at paragraph 59, has something to say on this point as well, just at the end. Lord Collins says that Lady Hale substantially approved the reasoning of Lord Justice Chadwick in Oxley. And it is inconceivable, in my submission, that no one would have said, of course, detrimental reliance is not required in this context. So at this point, I hope... I should also mention that the Law Commission paper, Sharing Homes, which is referred to frequently in these judgments of Stack and Jones, perhaps more in Stack than in Jones, is itself replete with references to detrimental reliance, albeit that the cases that are being analysed are sole names cases, because that's where the law was. Those were the cases that there were. So I hope at this point I can pause to say, in my submission, we have made good our first three answers to Malone and Friends' case. The first one, the idea that it's abandoned detrimental reliance. Stack is a stage in the evolution of the constructive trust, not a revolution, and so it's highly unlikely that the House of Lords would abolish or abandon key principles on which those judgments were built without saying so expressly. The most obvious reason why the majority of the House of Lords and the full court in Jones did not refer to the need for detrimental reliance is that it was not in issue. As a matter of fact, in either case, it was not an issue as a matter of law. The controversy in the law has very largely been about how do we infer a different common intention. And if we infer a common intention that's different, how do we quantify it? It's never really been about detrimental reliance because detrimental reliance has always come along with those same facts. It's always been there in the double duty being done by the contributions. And of course, the purpose of Lady Hale and Lord Walker giving a joint speech was to clarify what had been said in Stack.
They don't seem to have managed it quite.
I beg to differ, my lord, but
Well, Mr. Justice Carr didn't think so.
The second answer that we have is that they didn't, and I've already made my point about paragraph 49 in Lady Hale's speech in reference to Goodman and Gallant, and how I say that it clearly implies that she did not think common intention alone was enough. And the third answer is that it is obiter, strictly speaking, because it wasn't an issue. But it follows in my respectful submission the dichotomy that was presented by Mr. Justice Carr at paragraph 61 of his judgment as to whether the Supreme Court had omitted to refer to detrimental reliance because it didn't need to be proved, or because it didn't arise on the facts of that case, has the opposite answer for the one that his lordship alighted on. Post-Stack, we do of course have a myriad of judgments where the need for detrimental reliance has not been mentioned, but that's precisely because their lordships, as one might expect, cite the principles set out in Stack, and they are enough to determine the cases before them. So they don't need to say anymore. They don't need to rehearse Gissing and Lloyd's and Oxley. And so far as we are aware, in every case in which beneficial interests differing from the legal title have been established, the party benefiting had in fact relied on the common intention to their detriment. So I really do put my case that high, that every case, be it sole names, joint names, commercial or domestic, whether detriment was an issue or not, every successful constructive trust claim did in fact have detriment. And it follows from that, of course, that my learned friends have not a single case to support their proposition. Very briefly, looking at these post-Stack cases, we have Acquaintance and Tandon, which was a case of abandonment. One party had paid for everything.
Sorry, which one?
Acquaintance and Tandon, which is tab 16. It was bought in joint names in 1999. The defendant moved out between 6 and 12 weeks after it was bought. He had made no contribution to his acquisition, and the claimant then continued to live there for another 6 years, paying all of the outgoings on the property. So clearly the claimant's detriment there consisted of contributing everything in the expectation of getting everything, and so it was held. Detriment was obvious. Agarwala is a case where Stack and Dowden was applied. It was a commercial case in a single name, and the point is that Stack and Dowden is being applied to a commercial case, to a single names case. That shows us how the courts accept that Stack and Dowden applies to both, to all scenarios. Smith and Bottomley is a Court of Appeal case. Lord Justice Sales emphasised the importance of detrimental reliance being a critical element of the claimant's claim to a beneficial interest in the properties in question. I have to apologise because I think I reread this case and I think the summary of it in my skeleton argument is not quite right. In fact, it doesn't have a joint names case in it. The properties in question, the sole name.
Well, the claim against a company, it was said that the company hadn't made any promise, so the claim fell for that reason.
Yes.
But in addition, Mr. Justice,
yes, there was a property that was in joint names, but that wasn't subjected to a constructive trust analysis, so that's where I'm afraid I fell into reading it too quickly. Collins and Curran, my lord has mentioned, and I therefore don't need to go to it. Safe to say that I think your lordship records that counsel rightly abandoned the argument that detrimental reliance was not needed after Stack and Jones. And what your lordship did not go on to say was that if this was a joint names case, things would be different. In my submission, that's a pretty clear steer from this court and your lordship in particular as to the judicial tide. Barnes and Phillips, I need to look at a little bit because it was relied on by my learned friend. My learned friend says, and Mr. Justice Carr thinks it supports his position, because what he says about it in his judgment is the notion of detriment does not appear to have played any part in the second ambulation, whereby Miss Phillips' share increased from 75% to 85%. That's a pretty thin basis for supporting Mr. Carr's Mr. Justice Carr's position, given that detriment wasn't being argued by Mr. Horton in that case. But even that, I say, is wrong. It was a joint names case. There was the remortgage in May 2005. We see that in paragraph 7. The relationship breaks down 1 month later in June 2005. Sorry, did I say 2007? I meant 2005. So the remortgage in paragraph 7, May 2005. The relationship breaks down the following month. We see that in paragraph 9. And then by 2008, the respondent has taken sole responsibility for all payments, including the works.
Yeah, Lord Justice Lloyd Jones deals with that at 37, doesn't he?
Yes.
Subsequent events required a further adjustment in the intention to be imputed.
Yes.
And he talks about the appellant having failed to contribute towards the mortgage 6 years up to trial, necessary to vary the intention to be imputed, and the further adjustment of 10% was justified by in effect, by the conduct.
Well, perhaps I don't need to say much more about it, but the point I wanted to emphasise, and the reason I asked my learned friend to take your lordship to paragraph 36, is that this is all at the quantification stage, the imputation stage. There had previously been a finding that there had been a common intention to vary. That was supported by detriment, the first ambulation. Then matters went on. That's the imputation, because the shares were not agreed at that stage. Then there was the quantification type ambulation. So whether detriment was required for that second ambulation is moot. I think the lordship said that probably not, but that's because it's at the second stage. It's a case where the common intention does not descend to the detail of the shares. So the two answers to the judge's reliance on this case. The first is that he has misunderstood what is going on. The second so-called ambulation is not based on an inference of any change in common intention. The common intention to share in unresolved shares has already been inferred, and that imputation is not dependent on detrimental reliance, which was the second ambulation. But in any case, there was in fact detrimental reliance on the facts of this case, on the second ambulation as well, because it's in 2008 that one party takes responsibility in total for all the mortgage payments. And I've put in the bundle of authorities an article in the New Law Journal by two barristers at Falcon Chambers, and I just referred to it because it deals with the treatment by the appeal judge in this case, says that it's likely to come as a surprise to many. It says that in the absence of detrimental reliance, it's difficult to see what the normative basis could be for the intervention of equity to save an agreement that by statute Parliament has determined is unenforceable. Well, quite. Did your lordship have a chance to look at that? It's a short article, but I won't take your lordship to it anymore then. Montalto and Poppet is a case which illustrates there's no distinction as regards commercial and domestic cases. Taylor and...
I couldn't hear what you said. Which case?
Montalto and Poppet. Refers to the need for acting to one's detriment, paragraph 107.
Yeah.
Taylor and Taylor is a commercial case. Subject to the different starting point, you have the same. Taylor and Taylor's case, where His Honour Judge Matthews does deal with this same argument that is being essayed today. His Honour Judge Matthews, the point was taken that there was no reference to stack. His Honour Judge Matthews says yes, but that was a domestic case. This is a commercial case, so I'm not bound by it. But in any case, his lordship cannot resist commenting at paragraph 61. Let's just quickly look at it, my lord. Tab 23.
So he says it would effectively nullify section 53(1)(b.
Yes, it would drive a coach and horses through the statute, is what it says. Or words to that effect. Insol is the case that is absolutely on all fours with this case. It's a decision of Master Bowles. So it is a High Court decision. I know there's perhaps a debate as to whether that was binding on the judge as a matter of comity. But nonetheless, he is an experienced Chancery Master. He was also counsel in Lloyd's Bank and Rossett, as it happened, being led by Leo Price, Queen's Counsel. So it's a decision that's worthy of respect by Mr. Justice Carr, as well as your Lordship's own respect, suggests. But it cannot be distinguished on the basis that my learned friend has suggested, which is that there was an unsigned declaration of trust, because Master Bowles says, well, this declaration of trust was unsigned, therefore it's not relevant, and therefore I apply the presumption of beneficial joint interest. And it does apply. There was nothing to displace that presumption at the outset. Was it displaced subsequently? And his Lordship says, the Master says, detrimental reliance was needed. Common intention was not enough. That's paragraph 99.
Yeah.
But judgment. Marr and Colley shows us that, again, that at the highest level, I think four of the 5 judges sitting in the Appellate Committee of the Privy Council had been on the panels for either Stack or Jones or both, and they apply those principles to a semi-commercial situation. Semi-commercial in the sense that they were cohabiting partners, but they were building up a portfolio of buy-to-let properties. Your Lordship is, well, my Lord Justice Nugee is familiar with Amin and Amin and O'Neill and Holland. My Lady is very familiar with Parker and FCA. I might also mention Fatal and Fatal, which is a very recent decision from this year. It's a sole name case. It cites Stack and Jones and then expressly adds the detriment requirement to the analysis, and that is at paragraph 81, and I've put that in the supplemental bundle, but that's just for your Lordship's note. We have in the bundle of authority quite a lot of textbooks, and the only reason I put quite so many textbooks into the bundle is because Mr. Justice Carr says that authors of learned texts do not speak with one voice. And I countered that, as your Lordship saw in my skeleton argument, by saying actually they're entirely unanimous, and they are. And the 2 authors that are picked out by, the 2 textbooks that are picked out by Mr. Justice Carr are Megarian, Wade, and Lewin. The Megari point can be answered quite shortly by sorry, I've lost my place for a moment.
Page 818 of the bundle.
818, my Lord. I'm grateful, yes. That's a very helpful
Roman 2 is essentially your proposition.
Yeah.
Yes, I was going to try and I was actually going to take the point very shortly by just looking at page 813 and the actual heading of the subsection, for which is the very subsection under which the passage cited by the learned judge is. That 813 the subheading at G is where a person has acted to their detriment and reliance upon a common intention, that person can acquire an interest in property or an enlarged share in property already co-owned. So that's pretty clear. That's the headline in Megarian Wave. And the footnote that is relied on in Lewin is at page 856 in the bundle. And this is the very thin basis for saying that the textbooks and all speak with one voice. It's footnote 318 on page 856. The requirement for detriment still exists, citing Taylor and Taylor. This was a decision in a business context.
Sorry, which footnote?
It's 318.
318.
The judge did not decide whether detriment is needed in the domestic consumer context, but we consider that the need for detriment is axiomatic in order to affect the conscience of the party, denying the interest of the party who incurs the detriment. C also, C2 insult. So this is perhaps a tendentious reading of the learned texts.
Oh,
Your Lordship's
used to be to say the absolute opposite of what the judge thought it said.
It's going too far even to say that they don't speak with one voice in
Yeah.
this submission, at least as to the fundamental point.
I mean, what they're saying is there are authorities that point towards detriment being relied on, they're still being required. One of them doesn't go as far as to say that in terms in relation for consumer context, but domestic consumer context. But here is the rationale for continuing with it.
Exactly. I've given your Lordships Underhill and Hayton and Emmett and Farrand. Emmett and Farrand is worth a read if one gets. I won't take your Lordships now because we're short of time, but just because it has been reissued since
This case.
and it comments, as I say, rather sarcastically upon it.
Comments on it.
It comments on it. It describes it as a rare dissent from the courts having otherwise emphasised that common intention not accompanied by detrimental reliance will not give rise to a constructive trust. Says that the conclusion drawn from this omission, that is to say the omission of the House of Lords to refer to detrimental reliance, was not the obvious one, that detriment was not an issue, which indeed it was not, or that equity's refusal to allow is an overarching principle applicable to all interventions by equity. I'll leave the... Oh, I just wanted to mention also that I have added in the supplemental bundle Gray and Gray, but only because it's a textbook which Lady Hale refers to a number of times in those cases. The reason I didn't refer to it earlier is because actually the 5th edition is now 13 years out of date, so there's nothing...
It postdates Stack and Dowden,
Postdates
not Jones and Kernot.
Exactly.
And I think in Jones and Kernot, Lord Walker refers to a different book by them called Land Law, which I haven't looked at.
Maybe I should have dug that one out. But, suffice to say, it's not complimentary about Stack and Dowden, but that's neither here nor there. It is the Stack and Dowden is the law. So just to finish on the first and second grounds of appeal then, my lord, the central strand of the learned judge's reasoning was unsustainable, that Stack and Jones had intended to abolish this requirement sub silentio. It's been said several times that the Court of Equity needs something affecting the conscience of the promissor before it can swing into action. Otherwise, it would be taking an axe to the statutory rules. Does equity have a role to play or not? If equity is just following the law, there's no further role for equity to play. There's no need for anyone's conscience to be affected. If equity is going to do something different, then someone's conscience needs to be affected and there needs to be detrimental reliance. In this case, we had 6 years of equity following the law, following the acquisition, and then there was a change. A further point that could be made in support of this argument that detriment is important is that there has always been this debate about whether proprietary estoppel and constructive trust are part of the same theory, have their origins in the same place. And there's never been any doubt that proprietary estoppel requires detrimental reliance. And the continuing importance of detrimental reliance was a point of common ground in the Supreme Court in Guest and Guest. So it would be incoherent to have a strand of the law based on proprietary estoppel that made representation enforceable only if one relies to one's detriment, and another strand of the law that makes it enforceable irrespective of detriment. The idea that single name cases and joint name cases, or domestic cases and commercial cases, should have different principles is also unsustainable. The cases have said over and over again that the principles are the same.
So does that make Lascar an outlier?
Well, Lascar essentially wasn't followed by the Privy Council.
Well, if it came to a choice between...
But it doesn't make it an outlier because all it's talking about is the starting point. All it's talking about is the presumption.
Yeah.
And obviously
if there were to be a conflict between a decision of this court and a decision between the council, I think we would have to follow a decision of this court, would we not?
But I don't dispute that the starting point in a purely commercial case may not be constructive trust, may not be beneficial joint tenants, that the resulting trust in that commercial context may still have something to say. What I do dispute is that if you're applying constructive trust principles, there's any basis for saying that detrimental reliance is no longer required. Because as a matter of policy, in the modern age, it is increasingly difficult to draw a bright dividing line between domestic cases and commercial cases. My learned friend said there was a clear demarcation, and that it really depends on there being a clear demarcation to make his position coherent. But there cannot be in practice. There are farms and farmhouses. There are people working from home in the little extension at the bottom, little shed at the bottom of the garden, which may have cost a lot of money. There are people doing therapies in their front rooms. There are other domestic economies going on, apart from the quasi-matrimonial, different generations of families all living under one roof. If the distinction is just about the starting point, that doesn't matter. The court can look at the facts, make a rational presumption, or make a rational inference as to fact of what the parties intend. If the difference was as to the requirement for detrimental reliance, that would make the distinction very, very important, and no one would know where to draw the line between the domestic case and the commercial case. So that would cause catastrophic amounts of uncertainty in my submission. So we respectfully invite your Lordship to reverse the appeal judge on this point. May I move on to the second issue, whether detrimental reliance was in fact present in this case? Various heads of detrimental reliance were put forward. We looked at those earlier. All but one were rejected by the trial judge. My client appealed on the one that was rejected, the idea that there was a claim, so pensions or shares or joint assets. The defendant, in effect, cross-appealed on a few of the ones that were rejected, and Mr. Justice Carr dismissed both parties' submissions on that. And it's only the one that was...
There's no respondent's notice on the question of mortgage payments or anything like that.
There was
this court.
No, not to this court.
Not in this court.
The only one now in issue is the claim to pension or shares, is what it's come down to. And as I've said, the defendant tries to insulate the trial judge's findings on this from attack by saying, well, it's a matter of fact or evaluation. And we say first that this particular type of detriment is very much a question of law, and our objections to it are therefore ones that can be made good without resorting to challenging findings of fact by the trial judge. The one objection we do have, that's a factual one, is the trial judge's failure to take on board the clear concession made by paragraph 19 of the witness statement of Miss Hathaway that she knew she had no claim to these assets, no legal claim to these assets. And of course, this court can interfere with the finding of fact made by a trial judge where it's plainly wrong or bits of evidence have been omitted.
I'm not sure about that last statement, that we can interfere simply because bits of evidence have not been recited in the judgment. I thought...
Oh, I entirely accept, not just because it hasn't been recited in the judgment, but because it's a piece of evidence that is stood uncontradicted and is flatly inconsistent with the finding that Miss Hathaway perceived she might have had a claim. She perceived that she didn't have a claim, unless you take claim to mean an opportunity to bring a moral.
Is there any difference in this respect between a first appeal and a second appeal, where you've got concurrent findings of fact? Well, you'll obviously be aware that the Privy Council have a rule that they don't disturb concurrent findings of fact except in exceptional circumstances. I don't know whether the same principle applies to this court hearing a second appeal.
Neither do I, my lord. I'll look into that perhaps and see if I can help your lordship with that. It's certain that there needs to be caution before the court overturns findings of fact and interfering with evaluation. But in this case, we submit the threshold is clearly crossed on that point. So let me address your lordship on the law first. What is detriment? Detriment must be substantial. We see that word several times in the cases. It must not only be de minimis. It must consist of doing something that the defendant cannot have been expected to do unless he or she was to have had an increased interest in the house. It is, as we saw in Austin and Keele, an irrevocable change of legal position, and this irrevocable nature is important. And as I've said, that's not just one example that Lord Oliver gave of a detrimental reliance. It was at the very least a bare minimum.
That's not quite how he puts it, is it? He says it may consist of something, of nothing more than that. I don't read that as saying that's setting a bare minimum.
Let me just make sure I've got the Fons et Origo before me. There has to be some conduct.
What he means by irrevocable.
Well,
I mean, when Miss Eves took her sledgehammer and broke up the concrete, in a sense that was irrevocable.
Yes.
They could have put it all back again, but in what sense is that an irrevocable change of position?
well, obviously the nature of detriment has moved on perhaps a little bit, in that we are now more accepting of things other than financial contributions. So, but if we're looking at but those sorts of factual contributions, you can't take them back. It's like in proprietary estoppel. Once you've worked for 20 years on the farm, you can't have those 20 years back again. It's not a legal change as such, but it's irrevocable. And my submission will be, as you've probably predicted, I put in the skeleton argument, if you desist from making a legal claim for a period of time, but you still have it, you haven't irrevocably changed your legal position. You've just deferred it for a while. And in O'Neill and Holland, detriment is, it was said, a description or characterization of an objective state of affairs which leaves the claimant in a substantially worse position than she would have been in, but for the transfer into the sole name of the defendant. I think that was my Lord Justice Nugee's characterization.
I think it was Lord Justice Henderson who gave the judgment.
Yes, of course it was, and Your Lordship agreed with it.
And the detriment in that case was, as it were, allowing the house to be in her father's name, or rather transferring the house to Mr. Holland's name when it had been in her father's name. Is that right? She didn't actually do very much of it.
Sounds right.
It's tab 31.
It is.
paragraph 69. I think. So Neil relied to her detriment on the assurances of Mr. Holland and her father that she was to have a beneficial interest in the property. The detrimental reliance lay in her agreement to the property being transferred into the sole name of Mr. Holland, when the previous intention had been to transfer into joint names. And the primary factor which caused her to give her consent was a false representation that he would be unable to obtain a mortgage. So she didn't actually do anything. She consented to a transfer which she had no right to.
Your Lordship anticipates the point about it being gratuitous, but on the other hand, it's from a different person. And I'll try and come back to that.
But you have made the point, or you certainly wish to make the point, in your proposed amendment to your grounds of appeal, that if you, as it were, give up something you've got no right to, that cannot amount to detriment, whereas O'Neill and Holland seems to suggest otherwise.
Yes, but the distinction is that the two gratuitous offers are coming from the same person in our case. So I'll just jump ahead to what I was about to say in a few minutes' time, which is that if I say to my learned friend, I'm feeling generous, you can have either my car or £10,000, and he says, I'll have the car. And before I hand over the keys, I said, actually, I've changed my mind. He can't say, but I've relied on that to my detriment by not accepting your offer of £10,000. Because they're both freebies. They're both gifts. The court is not going to enforce a gratuitous offer just because there's an either or in it. So I've jumped ahead slightly, but that's, I hope, the answer to that point. And as I just mentioned, the language of detrimental reliance is consistent between constructive trust and proprietary estoppel. In Guest and Guest, the majority held that the purpose of proprietary estoppel was to enforce promises, and that expectation, fulfilling the expectation, would be the default. And obviously that was only a bare majority. And I know it's not your Lordship's view from previous cases. But if that is so, if the default option in proprietary estoppel cases is to satisfy the promise, to give effect to the promise, then the analogy between constructive trust and proprietary estoppel has narrowed, has become even less than it previously was. But also, the House of Lords says detrimental reliance is still absolutely crucial in proprietary estoppel. And if there is a disproportion, a substantial disproportion between the expectation and the detriment, then the court may satisfy the expectation in a slightly different way. That's now more the exception than the rule.
Oh, wait a minute.
But you can't.
You can't do that with a constructive trust, can you? You can't scale down
You can't.
the interest because you don't think the detrimental reliance is up to much.
That's where the analogy breaks down.
In that sense, it's all or nothing.
Yeah. So I accept that. I'm not going to try and revolutionise the law of constructive trust in that respect. But the point I'm making is that the analogy is now closer if the default option in proprietary estoppel is to give effect to the expectation. Yet, detrimental reliance must be essential and it must be at least vaguely proportionate. So, if equity is going to operate in a principled and consistent manner, then surely it follows that the detriment in a constructive trust case must have a sufficiently substantial quality to justify the enforcement of the promise. Now, I'm not going to press that to the point of saying there needs to be a proportionality, but I'm going to say that it does reinforce the importance of it being substantial, not ethereal. So here's our word cloud for descriptions of detriment. Substantial, significant, irrevocable, objective, not speculative, not de minimis. Actually, I've forgotten to mention the not speculative one. That is in Steria and Hutchinson, which is one of the supplemental authorities. We find that in tab 5 of the supplemental bundle.
Supplemental.
It's a decision of Lord Justice Neuberger in this court. And I just ask your Lordship to read paragraph 127.
Right, paragraph 1.
127, which is page 39 of the bundle. It says, in essence, that detriment cannot consist of mere speculation as to what might have been.
This is another estoppel case, isn't it?
I read it as a constructive trust claim, but, well, actually it does say it's stopped, doesn't it?
No, this is an estoppel about a pension.
This is
Yes.
estoppel by booklet.
Yeah.
Stop off booklet, yes. The new doctrine.
Yes.
I
don't think it's a constructive trust case at all, unless I misremember.
No, I think your Lordship is right, but it's the same principle, and in my submission, what this is saying is that a detriment that consists of pure speculation as to what someone might have done in the future is not going to satisfy that. But also there's some comments in the other passages I put a line by which deal with the burden of proof, because there were some slightly difficult comments in Greasley and Cook by Lord Denning, which appeared to say that the burden was on, yes, and it is, and this is certainly proprietary estoppel, that the burden was on the promisor to show that the detriment hadn't been incurred in reliance. And Lord Justice Neuberger is saying, well, I don't think that's right. It's certainly not right as regards proving the fact of the detriment. And it's probably not even right as regards whether or not the detriment was incurred in reliance. The burden of proof could be important here.
I think there's some express dicta about burden of proof in Stack and Dowden, aren't there, that make it very clear.
Not in relation to detrimental
maybe
reliance.
Not in relation to detriment,
but certainly,
if you're trying to prove that that the situation is other than is presumed in law,
yes,
the burden is on the party who seeks to move to that position. And if it's a necessary element of that you've got to show detriment, then presumably that goes with the burden as well.
Well, my lady, I would agree, gratefully adopt that observation. In terms, it's related to the common intention, but that extension does apply in my submission. So, my learned friend, in his skeleton, puts it like this: the trial judge identified two possible courses of action, both of which the respondent gave up in reliance on their agreement. The first, a legal claim, and the second was, and I quote, some form of negotiated settlement based not on the legal merits, but on a common belief that the wealth should be shared. In circumstances where the court would have decided no payment should be made. That's quoting from the trial judge's judgment. So those are the two alternatives that my learned friend offers. I've tried to separate them out in the grounds of appeal so that it's dealt with more clearly than perhaps it was before. And I will deal with them separately if I may. As to the legal claim, the idea here is that the defendant might have foregone a legal claim of some sort to the claimant's personal assets. And the trial judge accepted that as a matter of simple law, Ms. Hathaway cannot pursue a claim for certain types of orders in this court. That's paragraph 65 on page 202.
Well, I think he was talking about the court's powers of redistribution at that point.
Yes, pension sharing orders, lump sum orders, so on. Not available to an unmarried former cohabitant. In the next paragraph, he says it may be that some sort of civil claim existed, like this one, in the form of a constructive trust or equity, which could have been mounted by Miss Hathaway, perhaps against the shares. It may have been a weak claim, but I cannot be convinced that it is a non-claim. And she then also says she gave up the claims she perceived she had, and which Mr. Hudson also perceived may be live, against the shares and pension. So it was acknowledged by the trial judge to be a weak claim, but it was never specified. It was never explained what the cause of action actually was. The trial judge was just guessing in a vague and unspecific way about what sort of claim it might be. But that, the trial judge said, was nonetheless a significant change of position. And this was the finding that was the subject of the claimant's original appeal. The part of the appeal judge's judgment that deals with this is actually very brief, and it's brief because he says, because of course he's found that detrimental reliance is not needed anyway.
Yeah.
So in a sense, although this reasoning is obiter, but rather than properly analysing what the trial judge has said on the different heads of detriment, he refuses to engage with it on the basis that these were not just primary findings of fact, but were evaluative, i.e. they extended to the judge's considered assessment of the quality and character of the primary facts and whether they sufficiently amounted to a detriment. And that's my learned friend's primary point, it appears on this second issue in the appeal, that your lordships can't review the appeal judge's decision or the trial judge's decision because it's evaluative, not legal. And I dare say that might be right as to whether certain activities or contributions of money were done in reliance on a common intention, and it may be right as to whether certain activities of a less concrete nature were sufficiently substantial. And the appeal judge was, in my submission, right to dismiss the respondent's cross-appeal on those additional heads. But with respect, it cannot be right as to whether a valuable claim at law or in equity had been given up, because that is self-evidently a question of law. The learned judge ought to have analysed the supposed claim to see whether the trial judge was right in law to decide that the claimant had a claim that had been foregone. And he didn't do so, and of course he goes, Mr. Justice Carr goes into a consideration of whether giving up a bad claim can amount to consideration at law as a matter of contract, which my submission is irrelevant. And even if it were a matter of evaluation, the trial judge did not, in fact, evaluate it. He didn't decide what the cause of action was. It's hardly his fault because it hadn't been explained anywhere. He didn't look to see what evidence in support of it there might be. He said it was weak. He said he couldn't be convinced it was a non-claim, but that was not based on any real evaluation at all. And so it is a situation, in my submission, where your lordships can properly review the trial judge's findings, the appeal judge having not actually engaged with that. And what we can see is that the extent to which the appeal judge does analyse the trial judge's findings, the reasoning has been infected by this contractual analogy which is out of place. This is paragraph 99 of the judgment on page 122 of the core bundle. Need to get out. Because in the middle of paragraph 99, if Lordship and my lady have got it, his lordship says the judge's thinking was in essence that it was the agreement between the parties that was all important. Was it? Not on my reading of the trial judge's judgment, because of course the trial judge doesn't go into this contractual analogy at all. That comment in that position in Mr. Justice Carr's judgment only makes sense if, at that point, the appeal judge is still hung up on the idea that resiling from an agreement is its own unconscionability.
Yes.
The idea which now my learned friends don't and can't defend. Had the appeal judge actually taken it back to the pleadings and to the evidence, the learned judge would have recognised what the trial judge didn't, that first, the defendant had no recognisable legal or equitable claim to the shares at all. She had not even attempted to articulate one, not in the statements of case, not in the evidence, not in the skeleton argument even at that last moment of my learned friend Mr. Holland. And that remains the case now, even today. It was the case before Mr. Justice Carr, it remains the case now. We still don't know, never been told, what the cause of action might be, apart from the apart from the judge's musing that it might be a potentially constructive trust or equity. And it was responded to on that basis. We saw 15.2 of the pleadings. The defendant desisted from making any claim against the claimant in respect of assets held in his sole name but acquired during the course of the parties' relationship. The response to that in the reply was the defendant had no entitlement to the claimant's assets. The parties were not married, and the defendant made no financial contribution to assets held in the claimant's sole name. Then we get to the defendant's witness statements. There's no mention at all of the supposedly lost or forgotten Children Act claim. And we get at paragraph 19, which is page 9 of the supplemental bundle, a straight-up admission that there was no legal claim. I knew that as we were not married, I had no claim to his shares or pension or to maintenance. But we had been together for 20 years, and Lee and I had agreed that there needed to be a fair distribution of the assets that we had built up together. And paragraph 23 is the other paragraph that my learned friend has mentioned in the context of his submission, that we are island hopping by saying what we said about paragraph 19. I invite your lordship to read paragraph 23.
Yeah.
She says, I was of the view that assets secured during our relationship were joint assets, however they were held legally, and we needed to reach an agreement. So that doesn't contradict what she says in paragraph 19.
You've also got to take into account what she says in paragraph 13, bottom of page 6. 3 lines from the bottom of the house. I had no pension, no guaranteed income, didn't relish the thought of a big mortgage and large house. We were certainly equity from our home and savings had been a manageable mortgage, and if things became tight, he always said his shares in Hiscox would be sold to pay it off. Now, we don't know quite exactly what was said, but there may be something in that.
We have some elucidation of that, if I may say so, my lord.
Sorry?
Page 60...
Page?
68.
68.
I think it is. And paragraph 38, which needs to be read in the... And sorry, also the last few lines of paragraph 37.
Yeah.
If you look at Mr. Hudson's email on page 36 of this bundle, 9th of November, second part of the page, his own attitude appears to have been to draw a distinction between things accrued while they were together and things that he's earned afterwards. Because anything that I've earned afterwards is mine alone. Anything while we were together is up for debate.
Yes.
Now, does that not tend to suggest that there's some common ground, that there's at least an issue as to whether she had a claim to share in the assets that he was able to build up because he was earning while she was at home looking after the children? It doesn't seem a million miles away from her own position.
The defendants rely on that email as showing that he would have been open to a negotiation about it.
Well, but that's a different question.
It is, and that's very much my point, that it has never been relied upon as the basis for a constructive trust claim or any other sort of legal claim. And that we have not got articulated in these witness statements, which have been drafted very much by lawyers because they follow the structure of the pleadings to a very great extent, any sort of legal claim spelt out. And it was not spelt out in the skeleton argument at trial either. And just where we were at paragraph 38, 39, when at the end of that witness statement,
So we're at 37, right at the end. This is Miss Hathaway 2, isn't it? Yeah. She says, my understanding was we would continue to pool our resources, and when we retired, we would live off our combined assets, which were accumulated whilst we were a couple.
Mm. But this is all prefaced and predicated by the bit at the end of paragraph 37. I believed that we were in a happy and stable relationship and that our relationship would endure. So by the time the relationship has ended, she's not saying anymore, I think I've now got a claim to these.
Well, she's not a chancery draftsman. I mean, she's clearly
But
told you
I know
what her
Mr. Holland
understanding
is.
was of what the family lawyers call the acquest.
Yeah,
And
it's not a family case.
as I said, it doesn't appear as if your client's understanding was radically different. Again, if you look at the top of page 38, he says, we'll sort out who deserves what in regards to our joint assets, house, shares,
Yeah,
savings.
and I entirely accept that that is being relied upon as showing that he was amenable to a negotiation because he felt as a matter of fairness that these are things that could be
Well,
different.
these are not lawyered emails. These are raw emails from the parties. It's not difficult to see in those circumstances where both parties appear to have thought that at least there was a discussion to be had about so-called joint assets, irrespective of the fact that the shares is in his name.
These are all post-split up, post-separation.
Yes, that's my point. That's my point. This is not, well, now that we've split up, I'm keeping it because it's in my name. Post-split up, your client's position, on the face of it, is that there is something that is open for debate, up for discussion, and so on, without drawing a distinction as to whether that's a purely moral claim or a legal claim. He's not a lawyer any more than she is. But these are things which need to be sorted out. And in that context, if what happened is she says, okay, I'll take the house, you have the shares, why is that not giving up a claim? As the judge says, it might have been a weak claim legally. Once the lawyers looked at it, it may have been.
Well, what I'm attempting to do is follow the approach that my learned friend has invited us to, which is to distinguish between whether the potential legal claim on the one hand and the moral bargaining position on the other hand.
It's not obvious to me that
And
your client and she are actually drawing that distinction in these emails.
No, well, I don't necessarily say they do, because as you say, they're not lawyered emails. But by the time we get to trial, we have no articulation of what the nature of this claim is. The words constructive trust don't, or it's simply not in the pleadings. It's not in, and the response, as I've pointed out in the reply, treats it as being a marital claim, and no one ever comes back and says, no, you've misunderstood, it's something else. You've misunderstood this. So it's simply not, it's not articulated. It's not, what one would have to have for a constructive trust would be there was a representation and I've relied on it in the following ways. We would need to go down there would need to be quite a lot of evidence to show that there was a constructive trust.
If you were trying to prove the claim, but you're not.
But it's not even been specified what the elements of it are. That's the point. And it wasn't even specified in a skeleton argument. And if it had been put in the pleadings, there was a claim in constructive trust, because at some point these parties thought that these were joint assets, and it could have been, then there would have been evidence. It would have been addressed expressly by Mr. Hudson in his witness statement. But it never was, because that was never put.
So where would that get you? Suppose that's what Miss Hathaway said, and Mr. Hudson denied it. He said, I never said anything of the sort. I never said we would pool our assets. I always said these are mine. You've got a dispute.
But Miss Hathaway hasn't even said that. She hasn't even said he told me this.
Well, she has said that her understanding was that they would pool their assets.
And when we come to, as I say, the next section of the witness statement, and in paragraphs 38 and 39, she lists. No, this is the first witness statement. Paragraphs 38 and 39. Page 19 at the very bottom, she says,
Sorry, page
19 of the supplemental bundle. Not only was I of the view we would reach a binding agreement in respect to financial matters, including the house, I acted to my considerable detriment. And here's what she says, what her detriment was. Investing the entirety of my inheritance in the picnic house, discharging the mortgage. There was a common intention. I acted to my considerable detriment by using my inheritance savings to pay the mortgage, the house's upkeep and outgoings. So she doesn't say in the witness statement, and I acted to my detriment by not pursuing a claim to pension or shares. She doesn't say she thought she had a legal claim there, or that she would have pursued a claim even if it was only a trial.
Well, she does say in paragraph 23, I was of the view which the assets, both of us secured during our marriage, joint assets, however they were held legally, and my view was we've been together for 20 years and my taking time off to look after our children and our home and to support him in his career advancement was one of the primary reasons he was able to earn such significant sums to build his pension and secure the shares. So they were our joint assets. I mean, that's her case. However strong or weak it is, that is evidence of what she thought.
Well, we interpret that as being her explanation of what she thought the moral position was, not as an explanation of that she thought there was a legal claim, because no one had ever said that this legal claim had that sort of character, as opposed to being a matrimonial character, which was how it was understood. Bearing in mind that it came immediately in before a supposed claim under the Children Act, when the two children were adults at the time. So, you know, it was of a piece with that.
Yeah, no, we've understood the point you're making.
So my first and primary point under this ground is that the trial judge's finding that the defendant had a legal claim to give up was not open to him on the evidence. And so it wasn't enough for the trial judge to say that he could not be convinced that it was a non-claim, because that was wrongly to put the onus on the claimant. Whereas, as we have seen, it is for the defendant to adduce a positive case that she had relied on the agreement to her detriment, not for us to prove a negative. We didn't even attempt to prove a negative because it wasn't set out in that way. Objectively, it is not for the trial judge to speculate about what the claim might be for the first time in his judgment and what evidence in support of it there might be if the defendant had not actually made a positive case. Objectively, we say the claimant had no share, the defendant had no claim to the pension, she had no claim to the shares, just as she had no claim under the Children Act. Agreeing to bring a claim that doesn't exist as a matter of law or equity, my submission cannot be a detriment of substance or significance, and so she has not changed her legal position irrevocably or at all. It is not just the merits of the case that were non-existent or at best speculative. The value of the claim was also speculative because Miss Hathaway says in her evidence that she didn't know what the shares were worth. And Mr. Holland, in submissions to the trial judge, said the same thing. It was part of his argument, indeed. He said, we will never know what these are worth. The reason is because Lee has not provided the information to allow us to make the decision. We don't know what his shares are worth. Of course, an order for specific disclosure could have been made, applied for, if it was relevant. And the fact that that elementary step of case management was not followed is indicative of the fact that everyone knew there was no claim, so it wasn't worth pursuing that step. So the defendant had adduced no evidence as the supposed value of her claim either. And so again, there's no proper basis for the judge to evaluate it. And the next point is not about the existence of detriment or not. It's about the reliance point. The next point, crucially, is that the defendant's own evidence established, as we've seen, that she knew she had no claim. On my reading, the reading of the evidence that I've pressed on you, that is not contradicted anywhere else. But that evidence is not alluded to by the trial judge. He says she gave up claims she perceived she had. But let me say something about objectivity and subjectivity. Detrimental reliance has an objective element and a subjective element because it's a phrase which combines reliance and detriment. Reliance is a subjective quality, of course. What did this defendant do and why? Detriment, as we've seen, is an objective test. So the fact the defendant did not think she had a legal claim is, I accept, irrelevant to the question of whether she in fact suffered an objective detriment by not bringing a legal claim. And we say she fails to satisfy the burden of proof on that.
What about page 46? This is her email of the 12th of August 2013. This is after he's emailed saying, take the house, I don't want it. She says, your suggestion, as I understand it, is you get, note the word get, not you keep, you get sole ownership of your shares and pension. I get the equity from the house. Is that right? He replies, yes, that's right. That's when she gives up those claims. That is it.
She gives up her right, her moral opportunity to make.
Well, whatever it is she's giving up, that's when she does it.
Yes.
And she quite plainly does it on the basis that she has been told she can have a house. So she's relying on being told that she gets the house in order to give this reply, whatever it means.
Yes, but there are the two elements, and I've interpreted this as relating to the supposed moral claim.
You're trying to draw a sharp distinction between a legal claim based on a constructive trust and a moral claim based on 20 years living together.
Yes.
But it's not obvious that the parties are drawing that sharp distinction.
No, but we have to approach it as lawyers, even if the parties haven't.
Do we? I mean, no. I mean, it's not a facetious comment. If you say, "I'll give up any claim I might have," brackets, whether legal or moral or otherwise, is that not giving something up?
Well, let me try and put all my points across, and then we can see where your lordship's observation has taken us. Because obviously, I've got some more to say.
But you see, you want us to characterise this. She wasn't giving up a legal claim because she didn't have a legal claim. She wasn't giving up a moral claim because it doesn't have any content. But if she just says, as my lord says, you get to keep your shares and pension, she's not analysing it as a lawyer into, do I have a claim under this act or that act or that or whatever. But she is, in her own mind, in her own words, giving up any claim she might have.
Is your lordship point one on reliance, or is it one on detriment? Because if it's detriment we're talking about, then it must be objective.
Well, I'm not sure that means that subsequently some judge has to say, how much was this really worth? If what she's doing is giving up her...
Well, the courts in proprietary estoppel cases will have lots of people coming in front of them and saying, this is absolutely terrible, I've missed Doctor Who for the last 3 years, and that's a huge detriment to me. And the court will say, well, no, it's not. You could have watched it on catch-up. The fact that this particular defendant thinks they've suffered a terrible detriment is neither here nor there. The court has to analyse it objectively.
Okay.
And even the contractual analogy that Mr. Justice Kerr falls back on, that collapses under paragraph 19 of the witness statement, because even in contract, giving up a bad claim is only good consideration if the putative claimant thinks it's a good one. My submission is that she simply has never set out what the legal basis for the claim is. Maybe we can piece it together from an email here and a line in a witness statement there. Maybe that's what the trial judge has done, but the trial judge ought not to have to do that, because the burden is on the defendant, in this case, the claimant in the normal case, to establish that there is a detriment. Not for a trial judge to speculate about what there might be.
Yeah.
And the claimant also knew that the defendant had no claim. Yes, we've seen emails from 2011 where Mr. Hudson is feeling well disposed towards Miss Hathaway, and he says, well, we should make a decision about these assets. But by the time we get to the offer and acceptance, 31st of July 2013 is the offer. Page 45, by the time we get to that, what he says is, here it is. We were never married. You have no claim over what is mine. What I consider ring fence is what I get from my years of personal graft at my work. My shares and my pension, they are not up for discussion. I'm not agreeing to give you any. It's 2 weeks later that that's accepted. So contrary to the trial judge's suggestion, by the time the agreement is made, the offer is accepted, he did not consider any claim against them to be live, certainly not any legal claim. And he knew that there was none. And when the defendant replied to accept the offer so as to establish the informal agreement, she knew full well she was giving up nothing of value, because there was no threat of a claim that she could make or had ever made, in the hope that the claimant would fall for it. So we say that was no detriment at all.
Sorry, say that last bit again. She knew she was giving up nothing of value because she never made a claim.
She knew full well she was giving up nothing of any value because there was no threat of a claim she could make.
When?
Even in the hope that the claimant would, by the time she sends her email accepting it.
Right.
He's said to her what she then says in her witness statement, you have no claim over what is mine.
Her response is, well, I can't see any point in putting my side of the argument, not because I don't think I don't have a claim, but because we're not going to agree. I'll take your deal.
Well, it would have been open for her potentially to, by the time she gets to trial, she needs to tell us what that claim is. But she can't pretend. Maybe this is a point for the moral claim aspect of it, but she can't pretend that she thought there was something still on the table there by the time she accepts that. So my submission, by declining to engage either with the law behind the supposed claim or with the evidence behind it, the trial judge had not carried out an evaluation. The appeal judge fell into error by failing to observe that there had been no proper evaluation and failing to analyse it. And then the point about the legal claim is this, a further point about the legal claim is this, and this is ground 3.2 of the grounds of appeal. If there was a legal claim and it was an equitable claim in constructive trust, then she still has it. As a matter of law, she has not foregone any claim she might have had. The promise not to sue, if that's what it was unenforceable for precisely the same reason that we say the offer of the equity in the house was unenforceable, because it was a part of an agreement for a disposition of an interest in land made invalid by Section 2. Mr. Hudson can't enforce her promise not to sue him for precisely the same reason that she can't enforce the promise to give her half the house. If the defendant attempted to sue for the shares now, Mr. Hudson would have all sorts of defences. But none of those defences would be, we agreed that you wouldn't sue me off for this, because that contract not to sue is invalid.
Why would it be a contract not to sue? Why would it not be, I give up whatever interest I have? Now, I'm not saying anything about suing.
Same difference. Sorry, maybe your lordship is right. It could be either, couldn't it? You could interpret it as I'm not going to sue for it.
Surely it could give rise to a promissory estoppel, because she says, I give up my right to sue in return for something else. He gives something else up to his detriment on this occasion, which is an interest in the property. Why is that not enforceable?
Because if one analyses it as a contract, a would-be contract, then as the defendant has until this morning analysed it.
Why should you analyse it as a contract?
As I say, my little friend has analysed it until this morning. I'm still perhaps marshalling my thoughts in accordance with your lordship's earlier
You've got tomorrow
invitation.
morning to do that.
Yes. As your lordship may have noticed, there's fewer pupils in court this morning,
Right.
this afternoon than there were this morning. But let's analyse it on that basis for the purposes of argument. If it is a contract, on the one hand, I'm going to give you proceeds of sale in this house when it's sold. On the other hand, you're not going to either ask me for or sue me for these shares and this pension. It's a wholly executory contract. There's been no part performance.
We're assuming that.
At that point,
I'm not sure it's a fair assumption, because he also said you can have the savings and the property and the chattels and so on.
yes.
So it's been implemented to some extent.
Yes, but only by him, not by her.
Well, query whether it's been implemented by her. She says, I'm giving up. You get sole ownership of your shares and pension. I will accept this. That's it. She's accepted it. She hasn't got a claim anymore. She's given it up.
If it's analysed as I had a legal claim, then it follows that what she's giving up is her right to sue on the claim, and that's what a claim is, the right to sue. So that's why I said there's no difference.
Well, if it were a constructive trust, as the trial judge thought it might be, it wouldn't just be a right to sue, it would be a proprietary interest in the shares. And the other assets, which she said in her statement, she thought they were pooling their resources.
But if my Lady Justice Andrews is right, and that if you have a contract, I will give you my interest in the house. You will give me your interest, if any, in the shares. And Parliament says that that contract is invalid because it is a contract for a disposition of an interest in land. And what one can't do, well,
what you're saying is if the bargain is unenforceable as a contract, then all options are off.
yes,
And either party can go back on the bargain that they've made, and that's good as far as it goes, subject to equity.
but promissory estoppel is not one of the exclusions from Section 2 that is mentioned.
No.
No.
And even proprietary estoppel isn't.
Although I think courts have said it is.
Well, the courts have been pussyfooting around the question for a while, haven't they, as to whether some proprietary estoppels will create a constructive trust. Won't they?
But also, in proprietary estoppel, as used to be the case with part performance, you are not suing on a contract, you are suing on the equities. Yes. Which are raised by your having done something.
Yes, but part performance is abolished by the same act.
Indeed, it was. But the equitable principle, or underlying part of performance, still informs things like Section 4, the statutory flaws and so forth.
Yes. So part performance expects some sort of irrevocable performance, doesn't it? In my submission, there's been no irrevocable performance. We come back to this irrevocable point.
Yes.
Desisting for a period from bringing a claim is not the same as foregoing a claim. And there is no limitation period on constructive trusts. Now, my learned friend has tried in his position statement, his skeleton argument, to rescue this point by saying, aha, the shares have been sold. And there are two answers to that. First is that, of course, selling the assets which are the subject of constructive trust does not defeat one's claim, because, of course, you follow the assets, trace the assets into the new value, or you have a personal claim. And secondly, the answer is that the evidence showed that he had sold the shares in order to fund this litigation. And that was his evidence of trial. I sold them, but that's because I've been put to expense.
Where's that?
It's not in the judgment, but it was in the evidence. I can find a note if you disagree. Thirdly, Mr. Hudson has never said that he's so impecunious he couldn't meet the claim for half the value of his shares. He said he couldn't easily provide security for costs, but that's, of course, a very different thing from saying that he's insolvent or nearing insolvency. He has assets, he just doesn't have liquid funds. And fourthly, again, if Mr. Hudson is in financial difficulties, then it's because of these proceedings. It's because of the costs he's been put to already. And one can hardly rely on bringing the claim itself in order to make good the detrimental reliance on which the claim is brought. That's a bootstraps argument.
I thought he brought the claim.
Yes, sorry, one can hardly rely on wrongly defending the claim.
Yeah.
So, turning then to look at it as a matter of opportunity to negotiate, on the assumption there is no legal claim, the question then is whether the defendant has suffered a detriment in reliance on the agreement by failing to press a moral claim on Mr. Hudson on the basis that she might have prevailed upon him to give her some of his pension and or share save scheme through purely moral pleas. And the argument seems to be that if the defendant had not accepted the claimant's generous offer of half of his house and all of its contents and all of their cash and savings, she could have continued to appeal to his better nature for a share of the pension and the share save scheme instead. And that by giving her right to ask him for that, giving up the opportunity to further opportunity to ask for that, she suffered an objective detriment. I've already referred to the pleading problem with that, because if that's what the trial judge meant in his judgment, then he was going way beyond the pleaded case and way beyond what was argued in the written submission to Mr. Holland. I've already referred to paragraph 15.2 and how it's put, and I heard my lady's observation that she hoped I had other points to make. But in my submission, when you look at 15.2, it is not suggesting that the claim referred to there is anything other than a legal claim. One would need to plead quite clearly if one was saying that the detriment consists in giving up the opportunity to ask for something on a moral basis. So while the pleadings were thin on what the legal claim was, there wasn't even a whisper in the pleadings on either side that what was an issue was a moral claim, the loss of an opportunity to negotiate on a moral basis. And that's not just the technical point, the technical pleading point that the learned friend could remedy by applying to amend now, because if it had been pleaded properly, there would have been evidence addressed to this question of whether there was a moral claim, as I think I've said. The trial proceeded on the basis of the pleadings as they stood. Page 165 in the supplementary bundle is what Mr. Holland said in his skeleton argument at trial. many documents open now. In reliance upon the explicit agreement that she was the sole
Hang
beneficiary.
on a minute. 165. You said.
165 in the supplemental at 41.1. I told your lordship several times that it wasn't articulated.
Yes.
That it wasn't articulated in the skeleton argument, and that is it. That, what is it? 8 words is the sum total of the explanation of what the legal claim was, and, if that's what was really pleaded, what the moral claim was.
Yeah.
That's all the trial judge had to go on at the outset of the trial. And my learned junior's skeleton argument in response was directed to that. There is no evidence, she says, that there was any legitimate claim. There is no evidence that she gave up anything of value, that Miss Hathaway gave up anything of value. So building on your lordship's memorable remark, if I may say so, in the FAGE UK and Jabani case, in the context of an attempt to advance arguments on appeal that are not featured at trial, the trial is not a dress rehearsal, it is the first and last night of the show. And it's no good trying to have another go at one's grand soliloquy as the audience is already in the bar. And that's really what this is. The trial judge has made a few comments, a few passing comments about, well, maybe there was some opportunity to ask for something additional. But it wasn't pleaded in that way at all. And I hope I've done my best to convince your ladyship that there is something in the pleading point. So it was not open on the pleadings to argue for a detriment persisting anything other than the loss of a legal claim. And it was not open to the trial judge to decide it on that basis. And that is the end of the defendant's case so far as the moral claim goes. But there are more objections than just the pleading point. The factual objection is that it doesn't stack up. True it was that there is an email that says that, or the trial judge said they both believed in the concept that wealth generated whilst the family was together would be shared between them when they separated. But in fact, that was only true for a time. The emails back in 2011 showed that was the case, that he had at one time been prepared to consider giving her some of the shares. But the quotation by the appeal judge in his judgment is truncated what the trial judge actually held when we read in context in paragraph 65 of the judgment.
Whose judgment are we looking at now?
This is the appeal judge's judgment.
Yeah.
Page 202. No, that can't be right.
That's the trial judge's judgment.
Trial judge's judgment.
Sorry, yes, the trial judge's judgment.
Sorry, you said the appeal.
I did, and I'm
Right.
confusing myself. It was the appeal judge has truncated the quotation from what the trial judge said. Paragraph 65, what the trial judge says is, however, this is 5 lines down in paragraph 65, these parties were together for a long time, 20 years, and the evidence shows, until Mr. Hudson's angry July email at least, that they both believed in the concept of wealth generated whilst the family was together.
Yeah.
And that was the point I was making earlier in relation to the legal claim. That by the time Miss Hathaway accepts Mr. Hudson's offer, she can be under no illusion as to Mr. Hudson's willingness to part with his shares. They are not up for discussion. I'm not agreeing to give you any. And crucially, it was not put to Mr. Hudson that he would have agreed to give her any of his shares if she had asked after that point in time. The second factual point on it is that there was no evidence that the claimant declined. That had the claimant declined to part with his share in the house, the defendant would have persuaded him to give up his shares with a moral claim. My Lord Justice Nugee has pointed out the points in the evidence where she says, well, I thought they were joint assets. But what the evidence is silent on is the idea that I would have persuaded him to give me something, irrespective of the legal claim, just as it's silent on the idea that I would have sued him if he hadn't given me something. Thirdly, there are real practical difficulties. It was impossible for the claimant to give the defendant a share of his pension. A pension holder can't just assign pension benefits. What both parties were after in this case, and certainly what Mr. Hudson was after, and his emails say so in terms, was a clean break. As soon as possible, having to hang around until he became of pensionable age in order to realise some of his pension pot was not going to be a workable solution. And the same difficulty or similar difficulties apply in relation to the employee share save scheme. Mr. Hudson had said in evidence that the shares in the scheme could only be sold once he had worked at his employment for a certain number of years, as is normal. Until that point, they were effectively worthless. So again, a deal based on these...
Well, I'm not sure that's right. They carried a right to dividend.
Yes.
Mr. Hudson got very upset.
Yes,
Because the
I accept
dividend
that.
check was opened. He could have declared himself a trustee of the shares, even though they're locked up in the scheme until he can sell them.
Yes, but it
For
would
a
not.
dividend
It would have. But it wouldn't have given him the parties that clean break that they were after for a period of years.
Yes.
So it would have tied these two parties, who, as at July 2013, we could see are not on good terms anymore. It would have tied them together for years to come in a financial way. So it wasn't workable. And Mr. Hudson, of course, had already agreed to let her have all the cash in the joint accounts, all the mortgage endowments, and he was continuing to pay towards the cost of living in the house until it was sold, and he was hoping that was going to be sold very soon. So drawing all these points to...
Where do we find the evidence about this?
Which aspect in particular, my lord?
About the shares being locked up and he can't sell them and all that.
That was in all evidence.
Do we have any of that?
We don't have a transcript before the court.
No. So he was asked about these shares, was he?
He was asked about them to that extent, yes.
In what context?
Can I just turn my back for a moment, my lord? Well, what I can do, my lord, is circulate a note that was taken by my learned junior's pupil during trial of that cross-examination, and we
Well, I
can
don't
seek
know
to
quite
agree
what
it.
you're making at this point, but there's no trace of it in the papers I've read so far.
Well, I've made the point that there were in the skeleton argument. I made the point there were practical difficulties with dividing up those particular assets in a clean break basis. So this is not, well, sorry, I won't, nothing further on that. So drawing these factual points together, again, the burden of proof is throughout on Miss Hathaway in relation to all of this, to show that she did suffer a detriment, and that otherwise she would have tried to persuade the claimant to give her shares or the pension, and that she would have agreed. And the evidence to support that simply wasn't there. And that's not surprising, of course, in circumstances where it hadn't been pleaded in that way at all, certainly not clearly.
I'm trying to think of the ramifications of this line of argument. I'm not saying you're right or wrong at the moment, but in practically any case where the party claiming reliance in the relationship has not contributed financially, and therefore can't use that as a detrimental reliance on the deal, is doing no more than they have already done in the past, which is looking after the children and maybe making other sorts of contributions. If you are right about this, I would find it very difficult to conceive of a situation in which somebody in Miss Hathaway's position would ever be able to establish the necessary detrimental reliance to be able to show a constructive trust. That may well be the necessary concomitant to the argument that you're putting forward, but you see, somebody will not have a crystal ball, so they're not going to be able to say how their partner would react if you turn down the offer on the table and ask for something more. It will be pure speculation and it will be dismissed as such. Mm-hmm. If the contract is unenforceable, then you would always come back with that, with the point, the contract's unenforceable, you can still make a claim if you think you've got one.
Yeah. Well, in my submission, that's not a bad thing. This comes at the end of the relationship. There's a presumption of beneficial joint tenancy. Everyone has a share in the house. No one is going empty-handed. There has been, post-breakdown, an offer which is essentially gratuitous to hand over a share in the house. Parliament has laid down formalities in relation to that. It does require something substantial and not speculative to be able to enforce that in the teeth of the statutory formalities. But I think the problem your Lordship is grappling with is maybe more imagined than real, if I may respectfully say so.
Because? I mean, this is not an unheralded situation. What we have is, on the face of it, a contract that Parliament has said you can't enforce without certain formalities. But that is subject to constructive resulting or implied trust, whatever implied trust means. We're here in the field of constructive trust.
And the reason I say, the reason I say it's more imagined is that we have a whole slew of cases in which people in this position have succeeded in showing detrimental reliance. In all sorts of different ways, mostly by way of contribution to...
Well, it's mostly by way of financial contribution.
But if that's post-separation, post-agreement, and in circumstances where this person already has a beneficial interest, I'm not... in my submission, there's no social evil that needs to be corrected here.
All right.
Yeah. I think we need to move on a bit.
Yes, I'm so sorry. So the legal objection to this head is that there has been no case cited for the proposition that detriment can be found solely in giving up a chance of successfully beseeching the promisor to give the promisee something else than what was promised when the promisee doesn't have a legal entitlement to that. So this is unsurprising because it doesn't have the objective, substantial and irrevocable character that's required of detriment. Because it's pure speculation as to how it might have happened, how things might have happened if things had been different. We're looking for concrete things that the defendant did do in reliance on the agreement. We're not speculating as to what might have been. Now, the answer to my lady's point is that if there had been a pleaded case, that in fact there had been a promise in relation to the shares and it had been relied on, for example, and we would not be looking at a speculative moral claim. That point would apply. But let's assume, contrary to the facts, that the defendant could establish on the evidence that she would have asked for some of the shares, and that Mr. Hudson would have given her some of his shares, despite then being no legal claim. My submission is that would still not cut it, because in the absence of a legal claim, the offer to split his pension or his shares with her was purely gratuitous. It would have been a gift, it would have been a freebie. And that's the point that I accelerated earlier by saying to my learned friend, if you can have a £10,000 or a car, my learned friend can't enforce either of those options because they're both gratuitous. And as I say, I can allow for the sake of argument that it might be detriment having lost out on the opportunity to receive something from a third party. If I hadn't accepted the offer of a farm from you, Dad, Uncle Tony would have given me his farm instead. That's a sort of scenario you can imagine happening in an agricultural situation. But that's a third party. It's not this situation where it's the same promisor saying you can have A or B, but not both. And the court enforcing that just because there's an either or. So in my submission, this doesn't meet the threshold for detriment either. Therefore, it's not unconscionable for the claimant to retract his offer if the only prejudice suffered by the defendant as a result of that was the loss of a chance to beg for something that both parties thought she didn't have a legal claim to.
Yeah.
So bringing those two elements together then, sewing them together, when it comes to detriment, the legal claim on the one hand and moral bargaining on the other, my learned friends are on the horns of a dilemma. Quite apart from the fact that the former is non-existent in my submission and the latter is not pleaded, neither is evidenced. The dilemma is that if he's going to say the defendant had a legal claim, then he's still got it. Go on, sue on it. We can't stop her based on the agreement, we say. But if he's going to say that the defendant had a moral claim, then it's not detriment because it's gratuitous. So it's either not detriment because she's not given it up irrevocably, or it's not detriment because she's still a pure volunteer. In my submission, the trial judge was plainly wrong to think that there was any detrimental reliance in that 15.2 paragraph of the defence, and the appeal judge should have seen that and reversed him on that point. And we now submit that your lordship should.
Yeah.
Well, unless I can help your lordship any further, here's my submission.
Thank you very much, Mr. Lim. Yes, Mr. Horton.
My Lord, I think there are a number of different areas, and I'll attempt to organise them if I may. The first is some legal points about the nature of detriment, because before Mr. Justice Kerr, there was an express ground of appeal that said the trial judge had got the law wrong, effectively. That is not expressly in the grounds now, but there is still the submission that Austin and Keel lays down a test for detrimental reliance, and indeed O'Neill and Holland laid down a test for detrimental reliance, and I'm afraid, my Lord, I'm going to have to deal with those again. So that's the first thing. My Lord, secondly, I do want to express my client's frustration in what is effectively an appeal against a finding of fact. And my Lord, I suppose the answer to your question that you posed to then a friend was whether there was any rule that the Court of Appeal couldn't do so. There's no rule, of course, my Lord. The test for taking an appeal on a second appeal to this court is either that there is a general point of principle that requires a second appeal, or there's some other compelling reason. So I dare say there may be some factual errors that leap off the page, which a first appeal judge doesn't deal with, that the second appeal warrants. But otherwise, as we say in our skeleton, we say second appeals are for points of principle, not appeals against facts, especially if they're not properly made first time round. And this one isn't.
Just on the question of the nature of the detriment, I think we were shown by Mr. Learmonth Mr. Holland's skeleton argument at trial, in which he quoted Yaxley and Gotts, or Gillis and Holt, I forget which.
My Lord, yes.
Do you want to go any further than that?
My Lord, not really. I mean, as I said, my submission is very simple. The judge had the cases, the relevant cases on detriment cited to him. He was fully aware of them. he knew what they were, and he didn't make any misdirection at all. And the idea that there has to be some irrevocable change of legal position, or that detriment must leave you substantially objectively worse off, those are the two dicta that are extracted from Boston and Keel and O'Neill and Hodder respectively. Are simply, in my submission, they're simply not legal tests. They are, as I said, my Lord, dicta. Well, there's that point which I need to make. I want to deal with the fact that we are dealing with findings of fact in circumstances where this court is really not even set up to deal with it, because, my Lord, you asked my then friend, have we got the transcript? No, we haven't. And of course, what happens is if you make it plain, as the rules and the practice direction make plain, that you're going to appeal on an issue of fact, and you say the learned judge was wrong in fact in that he found it this way, then that alerts everybody in the appeal process the need to obtain transcripts, to agree notes of evidence. And none of that's been done. Not even first time round. So the idea that this court is in a position to entertain an appeal on that, we say, is just hopeless. So that's another issue. My Lord, then I need to deal with what I'm going to say is ground 3, which is the notion that there is an exception to the general rule that detriment is non-technical, a broad inquiry, and therefore not susceptible to appellate review unless it's plainly wrong or some other standard of review which leaves the trial judge a margin, if it were, of appreciation in terms of how they make their evaluative decisions. Because it seems to be the case that the argument is made that every time detriment is alleged to consist, at least in part, of giving up a legal claim, the submission is the court cannot find such detriment to have existed unless that claim is fully litigated.
No, I don't think that's what Mr. Learmont's saying at all. He's saying that the legal claim must be identified.
Well, my Lord,
and perhaps even the building blocks identified. He's not saying it has to be litigated.
Well, my Lord, my understanding
if you postulate a dispute of fact, let us suppose, over a claim, it might well be detriment to give up your chance of vindicating yourself on the facts.
So, my Lord, my answer to that will be, when I come to deal with that point, is that this is effectively a pleading point that, again, we're two tiers too late. If that was going to be the case the way in which this case is going to be run, then it should have been dealt with as a case management direction before trial, to say you cannot make good your claim on detriment insofar as it consists of giving up a legal claim unless you provide some information about that. Well, there was no Part 18 request. Yeah. So Mr. Learmont says, well, we never got it. The correct is they never asked for it. And if they thought it was essential, they should have done. So that's another point I need to deal with, and I'd say I'll come on to that. And then there are some more general points, I think, in relation to detriment, which I don't think I'm going to be able to sort of synthesise more generally. So if I can deal with the first of those, my Lord, in terms of detriment in general, I think I wanted to start, if I may, with Grant and Edwards, if I may, because there is some useful analysis in the judgment of Lord Justice Mustill at page. His judgment begins at page 70 of the authorities bundle, and he analyses the nature of bargains at page 71.
Yes.
In subparagraph 4, and there are a number of different types, if it were, quid pro quo that he identifies. And we say that this is a classic example of subcategory A, where express bargaining with the proprietor promises the claimant an interest in the property in return for an explicit undertaking by the claimant to act in a certain way. And it is implicit in my submission. If we look further down at subparagraph 6, if the situation falls into that category, the only question is whether the claimant's conduct is of the type explicitly promised. Doesn't matter what the character is.
What did Miss Hathaway promise? Yeah.
My lord, she promised to give up her claim to the shares and the pension. And I suppose in relation to that, we've already seen some part of what's been called the offer email of the 31st of July 2013. Just can I take the court there very quickly? It's at page 45 in the supplemental bundle. So, my lord, there's a sentence about paragraph rather halfway down, the liquid cash. So there's the offer of the savings in the bank, the contents, and in relation to the house, it is said, take it.
Yeah.
It goes on, as for a will, if I were to die before it's sorted out, Heidi will have no right to Picnic House. So there what he's saying explicitly is it's not an executory contract saying you'll get the proceeds of sale. It is yours as from now if you accept this. And then the last thing I want to draw your attention to is the sentence, or the paragraph rather, beginning what I want. I mean, clearly, this was Mr. Hudson dictating terms or putting out his terms. And of course, he got what he wanted. He wanted an end to it. He did, and the last sentence of that is very clear. I don't want you hanging around for years to come with your hand out. And this is relevant. I'll come back to this point, if I may, in terms of the substantiality or whatever the right term is for detriment. You can look at detriment both from what a claimant gives up in terms of the value of what's given up, but also the value as to what is received by the other party. And there's clearly some value in that finality and certainty as far as the claimant, Mr. Hudson, was concerned. So that's the first thing I say about detriment. My lord, the second thing I want to say is in relation to Austin and Keel. My lord, that is an authority at tab 2, page 30 in the authorities bundle. The head note one can see at page 31. And the holdings A is effectively that the document relied on was not a declaration of trust. The second one, holding B, bottom of page 31, that document did not produce evidence of a common intention to create a trust. And even if it was capable of giving rise to that inference, there was no detrimental reliance. And then we see from the law reporter's view was that Gissing and Grant and Edwards were followed. So in my submission, that is a difficult submission to make, that somehow this authority is developing or departing from the tests for detriment that are set out in Gissing and in Grant and Edwards. And my lord, my lady, can I just quickly take you to part of the decision itself? On page 38, there is, towards the bottom of the page, an extensive citation from Gissing. And in particular, at the bottom of the page, there is the reference there to some assumption sub silentio that the claimant will do something to facilitate the acquisition or contribute to the purchase price or the like. Into the next page, page 39, this is the key important thing again that comes out of Gissing. What the court gives effect to is the trust resulting or implied from the common intention expressed in the oral agreement that if each acts in the manner provided for in the agreement, the beneficial interests will be held as they agreed. So if you make an express deal with a express quid pro quo and you keep to your side, that is detriment. And that's clear from the way in which it's expressed by Lord Diplock in Gissing, but also the way in which Justice Muskill analysed the different types of agreements and the different types of detriment. My Lord, in terms of the suggestion that somehow Austin and Keel is making...
So you say then that this is not simply the case of an executory contract where each side promises to do something in the future. This is, if you like, an immediate exchange of house on the one hand, possible claim to the shares on the other.
My Lord, yes. You get this, I get that. Is that right? Yes. There we are. And because he said, my wife, if I don't make a will, she still won't have any interest in it if I die, that's clearly accepting that the beneficial interest will pass, as long as the deal is accepted.
Was he married to Heidi at this stage?
I think he was.
Yeah.
He also says at one stage, I don't have any interest in whether you make £1 or £1 million out of it.
Well, yes. He washed his hands of it. I mean, as I say, he got what he wanted. He hung on to his shares, which there was... well, I'll say more about that in a moment. My Lord, if I can just finish this point on Austin and Keel, I don't know, it won't be that much longer in this particular point. You can see the reference at the bottom of page 39 into page 40, that's the passage that's cited, the need for some conduct detrimental to the claimant. And then there's this difficult phrase, even if only in the sense of irrevocable change of legal position, because there are many types of conduct, including conduct within category A in Lord Justice Muskill's analysis, that won't amount to a irrevocable change of legal position. They will be an obligation to continue to do things in the future. You will get 50% interest provided you agree to pay half the mortgage or contribute to the bills. Those are the sorts of things where you're not irrevocably changing your legal position at all. They're based on agreement to do future conduct. So I respectfully suggest that there was no intention to limit or to amend the test for detriment in that throwaway comment, if I can put it in that way, my Lord. My Lord, I'm able to move on, but I'm also anxious not to... I don't know what time your Lordship is thinking of rising today.
Well, we'll certainly sit till 4:15, but don't forget that when we come back tomorrow afternoon, we've got an additional point.
My Lord, yes. On O'Neill and Holland, the point we made to Mr. Justice Carr, and I make the point very quickly, is that O'Neill and Holland was a case where essentially the Court of Appeal was making inferences of fact from the trial judge's judgment because detriment had not even been pleaded in the first instance hearing. And so what the Court of Appeal did in that case was to say, well, we can see what the primary findings of fact were, and we take the view that, properly analysed, they support a finding of detrimental reliance. My Lord, the particular passage of page 691, which I think the letter has already referred to, but I can just go to there again, where there's a reference to paragraph 62, reference there to the detriment that's alleged to have been suffered by Miss O'Neill. And as I say, at the end of that paragraph, opposite letters G and H, you have the description by Lord Justice Henderson of what detriment is. Again, my Lord, I submit that in a case where Gissing and Grant and Edwards were cited, this is not intended to be somehow a gloss on those tests. It's simply a way in which the court, in effect, acting as a trial court or a fact-finding court or a court that's making a decision on the facts and saying, with the test that we have laid down by those other cases, we are satisfied that there was detriment here, notwithstanding, say, my Lordship's observation in terms of Miss O'Neill lost out, as it were, on a gift from her father, who gave it instead to Mr. Holland instead. So we say that that is not a legal test, but simply akin to a trial judge summarising the reasons why he or she found there was detrimental reliance on particular facts. Well, I'm just going to quickly make the general point, if I may, about the nature of detriment and the standard of review. And my Lord, that requires me to just ask you to look at Suggett and Suggett.
Yeah.
That is tab 17, page 351. This was a proprietary estoppel claim by the claimant John against the estate of his late father, based on a promise that farmland and accommodation would be his on the death of his father. There were findings of detrimental reliance by the trial judge, which are set out in extracts on page 354. And at paragraph 37, at page 357, the judgment of late Justice Arden states that it was for the judge to the matter of fact evaluation whether there was sufficient reliance on detriment. You can only interfere if it was perverse or clearly wrong, and she held on the facts of that case that the judge was entitled to make that finding. Now, that is hardly a surprising decision. It's true of many evaluative decisions, but of course it's part of the ratio of that decision. Of course, it's trying to say it's binding on this court. And so, as a matter of generality, at least, where there is a finding of reliance and detriment by a trial judge, then of course that is a matter of evaluation which the appeal court should only interfere in the circumstances that she says. My Lord, I'll move on tomorrow to the proposed exception, as it were, to that that my own friend deals with.
Right, and I think by tomorrow afternoon, preferably in the morning, so you can show Mr. Learmont, we need a formulated amendment to your respondent's notice to deal with section 53. My
Lord, am I right in thinking that we're not sitting till 2 tomorrow?
Correct. I'm afraid we have to deal with another application tomorrow morning, so we will be not before 2 tomorrow afternoon, and we will have to finish tomorrow afternoon. Until tomorrow. Thank you.